Could I just have your attention, please? There will be a slight delay of 3 judicial minutes. There's been some difficulty with the lifts, but we will be getting underway shortly. Thank you. Silence! Silence! All stand.
First, I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respect to their elders and to First Nations people who are present today and online. Mr. Sacker.
Court pleases, may I also acknowledge the traditional custodians and pay my respects to elders past, present and emerging. I'm both pleased and privileged that you invited me to make a few brief remarks this morning on this very important occasion. We were colleagues as barristers and as judges. It's fair to say we've known each other a very long time and we're very good friends. This morning marks an important milestone, Your Honour's imminent retirement, which will officially occur on 11 July and was announced by the Chief Justice on the 11th of June as part of the publication of Your Honour's impeccable report card. There are two occasions when a judge can be seen to do no wrong and is indeed said to be the quintessence of perfection. Those two occasions are a judge's swearing in and a judge's swearing out. At either event, it's customary for a member of the profession to spend much of their time exhausting their repertoire of superlatives. But today, as I know Your Honour is a man who above all else values candour, I feel under no such constraint. Your swearing in was almost 16 years ago to the day, on 29 June 2009. Then as now, members of your family are here. Your husband Paul is here, as is your sister Pam and her husband Russell, and your niece Julia, who is a solicitor. Your brother Michael, a neurosurgeon, is unable to be here. Others are no doubt watching on the live stream. You were admitted as a solicitor in 1975, spending a year as it then was Stephen Jackson Stephen, and you were called to the bar a year later on the 12th of March 1976. Your Honour was fortunate to read with a dear mutual friend of ours, Henrik Nicholas, also a judge of this court, sadly no longer with us. Your Honour had an exceptionally wide and diverse practice, taking silk in 1996. Sandy Street SC spoke on behalf of the bar at your swearing in. He was then the Treasurer. He spent what seemed to be an unseemly amount of time lavishing praise upon Your Honour's motorbike and leather accoutrement. I do not propose to return to that topic, although it must be said that, like Marlon Brando or Dennis Hopper, you do cut a fine figure when kitted out. What we also learnt was that Your Honour chose law over music or theology, although neither have been very far away from your routine activities. You've been the honorary assistant organist at Christ Church St Lawrence for many years. Your musical skills, however, are not confined to the organ. Amongst other skills, apparently, you are proficient as a trombonist. You're a founding member of the bar choir and remain involved. I'm not sure the choir has ever performed a piece written for trombone and voice, and there may be very good reason for that. However, there may be a gap which could be filled with some post-judicial activity. Many years ago, you wrote quite a long article about the restoration and replacement of the organ at St Peter's Anglican Church, Cremorne, where you had also been organist and choirmaster. You there displayed an extraordinary expertise in the somewhat underappreciated and little-known skill of organ restoration. Possibly another post-judicial activity, although I presume the market's rather small. Like every other judge appointed to this court, you've been subjected to the relentless but vital task of judgment writing. Your Honour is recorded as having given 1,036 first instance decisions across a wide spectrum of cases. You've sat in the Court of Criminal Appeal on 564 occasions, 12 occasions separately in the Court of Appeal. In addition, of course, Your Honour has presided over a very large number of jury trials, countless bail applications. Your Honour has for many years overseen the possession list, and you've dealt with on average 1,000 cases a year, and for example, in the years 2019 to 2023, 4,737 uncontested matters were dealt with, along with 335 contested matters. The socio-economic consequences of the possession list were highlighted by the Chief Justice in a speech to newly admitted lawyers when he said, "An individual in need of your services as a lawyer is in many cases an individual facing some great personal challenge or crisis, affecting his or her liberty, property, personal well-being or health or financial situation." The possession list, which Your Honour has managed since 2010, shortly after your appointment, is an example of a list which deals directly with those whose property, well-being, health and financial position is very much in crisis. It is some of the court's more difficult and sensitive work. This is where Your Honour's innate capacity for compassion and humanity was deftly deployed. The volume of work you disposed of more than adequately explains why a reference to the Supreme Court website exposes that you are not known for making speeches, and perhaps you're not even capable of having any time for gossip. According to Mr Bram, SC, a week or so ago at Justice Stevenson's swearing out, probably standing where I am, and in this very room, talked about some judges who in fact do gossip. Noticeably, he did not mention you. I can only say that I'm seriously considering serving a concerns notice upon him under the Defamation Act. Your tipstaves to a person describe you as the kindest person they've ever met and worked for, with endless patience, loyal to a fault, taking time to explain precisely what is happening in a case. They also mention your extraordinary discipline, with fixed times for your daily routine, which must include tea break with Fortnum and Mason's biscuits, and of course the gym. Try as I may, from my own personal knowledge and inquiries I've made, I cannot find, or have not been able to find, any negative thing about Your Honour. I have diplomatically, however, chosen not to consult your husband Paul, nor your long-term associate Anita. For many years, your close relationship with the Honourable Philip Hallam and Justice Harrison, Chief Judge at Common Law, has been the stuff of legend. Your weekly catch-ups, among other activities, became a ritual. Although by now a very old chestnut, it's worth noting that the analogy has often been made between the three of you and the Three Musketeers. One question, however, has never, as far as I'm aware, been addressed as to which musketeer each of you was. That question can be easily answered in your case. You're undoubtedly Aramis, a man who was torn between the clergy and his role as a musketeer. Another was, who was the most handsome? That can easily be answered and was made very firmly clear at your first meeting in your weekly ritual as to who that was going to be. But as he is yet to retire, I thought I thought I should be discreet and not take that any further. Our beloved Chief Justice, who has created an art gallery and a centre for the performing arts on level 13, especially with the addition of the Garling Memorial Grand Piano, is considering, I can tell you on this morning confidentially, installing the Davies Memorial Pipe Organ. And it may well be launched at the same time as the Judicial Wellness Retreat and Spa, which is going to be on level 13 and managed by the redoubtable Edwina Chapman. I have already qualified for that section of the Banco Court, which Justice Beech-Jones, when he formally left the court in 2023, described as Valhalla. One wonders whether he now considers himself in Nirvana. However, I thought he mentioned Valhalla in a slightly envious tone, and for good reason. Entering Valhalla, as His Honour Justice Beech-Jones clearly realised, brings an eternal end to reserved judgments. That is one aspect of the role of any sane, rational former judge will never miss. The joys of Valhalla await you. What next then? I do very much appreciate that it will not be a unilateral decision. Your husband Paul will undoubtedly have something to say about it. Travel, of course, and generously entertaining your extensive circle of friends amongst your superb art collection. You are now entitled to a well-earned rest in the certain knowledge that you can be justly proud of your achievements. The purpose of this morning is publicly to celebrate your Honour's dedication and commitment to the administration of justice in this state. You performed that role with distinction, skill, and above all else, integrity. On my behalf as a friend, but I'm certain on behalf of your soon-to-be erstwhile colleagues, other friends, family and profession, we all wish you the very warmest and best wishes for the future. If the Lord pleases.
Chief Justice, President Ward, fellow judges, Mr Toomey, President of the Bar Association, Ms Ball, President of the Law Society, my husband Paul, my sister Pam and brother-in-law Russell, who I'm delighted have come over from Adelaide, my niece Julia, who followed me into the legal profession and is now a very successful building and construction solicitor, members of the profession and friends. Thank you, Mr Sakar. I knew that I could rely on you to gild the lily up to but not beyond the bounds of credibility. We go back a long way at the bar and then on the court together, and I have always valued and enjoyed our friendship and with your wife Alison. I was sworn in as a judge of this court, as you've heard, 16 years ago this coming Sunday. They have been the happiest 16 years of my working life. A lot of people are to be thanked for that, and today is chiefly a day to thank those people. In the speech I made at my swearing in, I thanked those who had helped me get to the bench in one way or another, and I have not in the intervening years forgotten them. That included the solicitors who briefed me, the senior counsel who led me, the junior counsel who supported me and kept me on the right track when I was senior counsel, and my barristers' clerks, Ruth Ross and Paul Walker. I thank the three Chief Justices under whom I have worked. To Jim Spiegelman, thank you for the faith you had in me to recommend my appointment. To Tom Bathurst, thank you for giving me 3 more years than I had anticipated. To the present Chief Justice, Andrew Bell, thank you for making this court the most pleasant and desirable place to work, especially by organising luncheons and other functions to bring the formal divisions of the court together. It might be misinterpreted if the relaxed atmosphere here means that the court could be described as party central, but you get the idea. I thank the Chief Judges of the Common Law Division that I've worked under, Peter McClellan, Cliff Hoban, Robert Beach-Jones, and my good friend Ian Harrison. One of the nicest aspects of being on the court was the fact that I spent much of that time as colleagues here with 2 of my closest friends, Ian Harrison and Phil Hallen. Ian and I have been friends since 1969 when we were doing arts together at Sydney University. We both met Phil towards the end of the 70s when he joined us on 13 Selborne. We and our spouses, Paul, Julie and Vivian, have enjoyed so many good times together, including holidays and walking trips together with Judge Jim Bennett and his wife Marilyn. Their friendship means a lot to Paul and me. Now, speaking of Ian, there is something I would like to correct. At my swearing in, I mentioned that Ian and I shared chambers when we first came to the bar, and like most young barristers in those days, we struggled to make ends meet. I said that Ian had devised a scheme to avoid early insolvency. This involved delaying clearance of the cheques we wrote to our creditors by making pinholes in the barcode of the cheques. The pinholes meant that the machines that cleared the cheques would automatically reject them and they would have to be cleared manually. That gave us 3 or 4 extra business days before the money actually came out of our accounts. Since Ruth McColl was later heard to suggest that we had engaged in serious criminal behaviour, I thought it was time to clarify that when I said it was Ian who devised the scheme, I meant to say it was actually me. Nevertheless, it also needs to be said that once apprised of the arrangement, he took to it like a duck to water. So if Ruth was right, which I somehow doubt, it was a joint criminal enterprise, but my role in it was higher in the hierarchy of the syndicate. And if it came to the point, I would ask the sentencing judge to note that I had a far worse childhood than Ian. But I hope this correction or confession will give him some peace of mind in his remaining months. I would like to thank my associate Anita Singh, who has been with me since I came to the court. Some might suggest we played good cop, bad cop with recalcitrant practitioners, but I'll leave you to decide who was which. Anita, like me, is slightly OCD, but that is a particularly good quality to have as an associate. She had very efficient systems that made finding things very easy, and she has a good memory for the names of judgments I wrote that I have long forgotten. She kept me updated on my outstanding judgments on a regular, sometimes hourly basis. She was good at reminding me, although less kind souls might use a different word, of things that I had to do and places I had to be. We also shared almost identical political and social views, with the result that we could daily enjoy outrage and denunciation of political and other figures who did not see things as clearly as we did. I said almost identical views on one area of difference. One area of difference was the death penalty, which Anita would prescribe for most offences coming before the Court of Criminal Appeal. Then there are my wonderful tipstaves, many of whom are here this morning. All of them were frighteningly intelligent and motivated. Each year I thought the next one will never be as good as the one leaving, but they always were. Although they left me understanding that split infinitives were to be avoided, and that the verb to appeal is always intransitive, note to some judges and practitioners. They also taught me a great deal, not only about obscure aspects of the law, but even about English grammar. When I received applications for the position of tipstaff, I always looked first at what other things in life they were interested in. It was a given that they had distinctions and high distinctions in most subjects, or that they had won this or that prize during their time at university. I wanted men and women who were well-rounded and not someone totally consumed by the law. I wanted to be able to talk to them about their interests. And they were a terrific group of people. I have kept in touch with a number of them. They are doing exceedingly well in their careers, some as solicitors, some as barristers, and some in quasi-legal roles. I thank them for all they did for me. My present tippy Finn has been a pleasure to work with. Nothing is too much trouble. He is very smart, and his ability to find cases on any obscure point of law within minutes is exceedingly impressive. I regret for his sake that we did not get to do a full criminal trial while he was with me. I thank Christopher Bradford, Karen Jones and Jenny Hedge, the three common law registers in my time here, who were of considerable support and assistance, especially in the running of the possession list and the users group, not to mention finding new and unusual possession problems for me to solve. And of course then there is Milio, without whom the common law division would probably grind to a halt. Quite how he manages to control so successfully the competing demands of the division, with criminal trials constantly running over time, with new high-risk offenders constantly popping up and needing to be fitted in before the sentence expires, with bail applications constantly growing, and all of this with no or virtually no cases being not reached each week is an abiding mystery, but is also a testament to him. And I'm sure he would want me to say that without Rebecca Connor's assistance, he might struggle a little also. I could not have managed the possession list without both of them. Of the 4 CEOs at the court during my time, I have worked most closely with Chris Death and Rebel Kenner. Rebel, of course, was the prothonotary for many years before becoming CEO, and she provided me considerable assistance in the possession list and the users group. Chris Death, who is also a good friend, was the completely calm and unflappable CEO who, with Tom Bathurst, steered us so well through the pandemic and the floods. He was always available to deal with problems with considerable alacrity and great efficiency. He has now gone on to greater things within the department, but is still involved with the courts. If Millio is the mainstay of the Common Law Division, Nick Sanderson-Goff is the judge's sure foundation in the court. No problem is insoluble for him. Emails are efficiently responded to immediately, and there is nothing he does not know about the working of the court and about external matters which might affect the court and the welfare of the judges. My only criticism of him is minor. When I arrived at the court, he allocated to me the ceremonial robes formerly worn by Michael Adams. I have still not grown into them. Others with whom I have had regular dealings are Nathan Gray, Joey Orlins and Greg Byron, all of whom are always helpful and obliging in their various roles. I also wish Greg a speedy recovery from his recent health issues. I thank all of the registry staff, the court officers and the wonderful court reporters from reporting services, many of whom have transcribed in my court the whole time I have been here. I am delighted that Colette is here this morning. To the well-prepared barristers and solicitors who have appeared before me, it was a delight to have you in my court. The others probably know who they are. Judges can't do their job properly, or at least the task is very much harder, without the assistance they get from the lawyers who appear before them. Most lawyers are diligent and hard-working, and the well-prepared and efficient conduct of cases makes this job not only worthwhile, but also enjoyable. Finally, I thank my long-suffering husband, Paul. Being the spouse of a judge of this court is no easy matter. It's not only the judge who gets woken in the middle of the night while on duty to issue a surveillance device warrant. Then there are all the times alone on weekends or nights and the delayed dinners because something has arisen or has gone on longer than expected. Indeed, Paul says that he intends to write a book in retirement called, with a tilt to Samuel Beckett, Waiting for David. He has been a constant support throughout my time here. He accompanied me to all of the court conferences, and at the beginning of my time here, that was somewhat daunting. There were still a few judges on the court who did not even approve of gay people, let alone same-sex relationships. However, a number of the judge's partners took Paul under their wings and firm friendships were made. Paul, I thank you for all your support. One of the most daunting things about coming to the Common Law Division for a civil lawyer, as I was the realisation that I would need to learn about the criminal law and fast. When I first went to the bar, those older and I thought wiser told me I had to choose. One couldn't dabble in the criminal law. It was all or nothing. So I practiced as a civil lawyer almost exclusively, except for a PCA or two and some children's court legal aid work in my early days. Now I think that was bad advice. In my time here, I have come to love the criminal law. Peter McClellan sensibly eased me into it by sitting me in the CCA with the best of the criminal lawyers, from whom I learnt a lot, both on and off the bench. People like Peter Johnson, Robert A. Hume, Terry Budden and Peter Hidden were of enormous assistance to me, and I thank them for their patience. One of the tricky things about criminal law and practice was all the abbreviated references and the foreign lingo. Liberato, Markaleski, Black, Murray, Edwards, Mackenzie. Who were these people who seemed to be in every other case, I wanted to ask. Section 21A, special circumstances, exceptional circumstances, what was the difference? The proviso to what? Totality, parity, HROs, CCOs, CROs, ICOs. What helped was sitting in the CCA. It would have to be one of the most efficiently run courts in this country, that it can hear 3 or 4 appeals per day, 3 days a week, and mostly have its judgments out within a few months is no mean feat. That is not only down to the work done by the judges in advance of the hearings, it is also because of the generally high quality and comprehensiveness of the written submissions by the profession and the corresponding economy of the oral submissions. The criminal bar is to be commended for this. As I said at the outset, the last 16 years have been the best of my working life. The court is a very happy and collegiate place to work. That is due in no small part to the Chief Justice, the President and the Chief Judges of the divisions. It is reasonably well known that in years gone by, particularly at the time of the creation of the Court of Appeal and for many years after, there was a great deal of unhappiness within the court where some judges would not even speak to others. That often manifested itself in the way some judges dealt with practitioners who appeared before them. Things changed considerably when Michael Kirby, now the Honourable Michael Kirby, was appointed President of the Court of Appeal. I acknowledge his presence here this morning. He does me a great honour. The work of the court is relentless, but it is endlessly varied and intellectually stimulating. The Common Law Division in particular provides for the full breadth of practice, from serious criminal trials, the best of civil work, including appeals to the court from a variety of courts, tribunals and other bodies, as well as appellate work in the CCA. I'm sad to be leaving, but all good things must come to an end. I'm looking forward to the next stage of my life, which I hope won't be the last. Thank you for all of your presence here today. The court will adjourn.